Also call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Christian Borgesen versus Deborah Borgesen, case number 24 AP 333. Representing the appellant, Christian Borgesen, is Jean Kuehl. Representing the appellee, Deborah Borgesen, is Amy Goddard.
Thanks very much. Good morning, counsel. We'll hear from counsel for the appellant. Please, for the record, introduce yourself, identify your client, and then proceed.
Thank you. Thank you, Your Honor. I am Jean Ann Keywell. I am the attorney for Christian Borgesen, the appellant plaintiff husband in this case.
Thank you.
May it please the court, this case is a case regarding spousal maintenance. The parties are Christian Borgesen. He is 63 years of age. He works as a registered nurse and has done so for 35 years, the past 17 at Brattleboro Memorial Hospital. The appellee is the wife, Deborah Borgesen, age 60. She has worked at the same bank in Newfane, Vermont since graduating from high school for approximately 40 years. The parties were married for 25.5 years and had 2 children. The parties have stipulated that spousal maintenance is warranted in this case. The issues before the court are the amount and duration of spousal maintenance and the amount of property awarded in lieu of spousal maintenance. Appellant contends that the court has ordered plaintiff more than warranted for her to meet her reasonable needs. The appellee has stayed in the marital home with all the furnishings and has the same or better lifestyle than the parties enjoyed during the marriage. The party's adult daughter is residing there, and the appellee is providing housing for the daughter. The appellant was voluntarily paying spousal maintenance to the appellee during the temporary period, and the appellee testified at during the divorce hearing that she was meeting her needs with the amount that was being paid. Nevertheless, the court ordered a more than 100% increase in the amount of spousal maintenance that was being paid. And we would also note that the appellee's 813A affidavit included expenses that are not actually being paid by her, were not actually being paid by her at the time of the final divorce hearing, so that she was actually receiving in excess of what she stated her reasonable needs were at the time of the divorce. The court, she did indicate that things were tight, and the court proceeded to award her the maximum amount of guideline support without any, we don't think, without adequately considering what her needs actually were. There was no dollar amount finding by the court, family court, of what her actual need for spousal maintenance was. And secondly, the appellant argues that he cannot meet his own reasonable needs paying the amount of spousal maintenance ordered. He is living below the marital lifestyle at the time of the divorce. He's living in a sparsely furnished apartment, and he has a greater need for retirement savings than the appellee. I neglected to mention the appellee has a premarital retirement assets of $170,000 in retirement savings that she has available to meet her needs. Finally, the term of the spousal maintenance is the court.
You have 1 minute, counsel. You've got 1 minute left.
Thank you, Your Honor. We are arguing that the award in lieu of spousal maintenance was calculated erroneously because the court ordered that the appellant would be permitted to retire on his full Social Security retirement age, and which is in 4 years, but the court ordered a buyout of the spousal maintenance with property based on a term of up to 20 years. And the court also found that the appellant would not be able to pay the spousal maintenance at the level he was paying when he retired.
Okay. All right.
Thank you, Your Honor.
Thank you very much. Your time has expired. We'll hear from counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. May it please the court, my name is Amy Goddard. I represent the appellee, Deborah Borgesen, who is the wife in this divorce matter, as Attorney Keywell noted. So your honors are well aware that the standard of review in this case is abuse of discretion. It is clear from Mr. Borgesen's position that he disagrees with the trial court's order. However, he makes no showing that the trial court's order is in fact an abuse of discretion. So as Attorney Keywell noted, it was stipulated that Ms. Borgesen could not meet reasonable needs of the standard established during the marriage without spousal support. So that threshold issue was agreed upon by the parties. It is correct that the only issue here was the duration and amount. Again, Mr. Borgesen.
The duration, the way I read the order, duration expires in 2027, not 2028, which is the full Social Security age. So it's a 3-year award of support.
That's correct, Your Honor. At the hearing, Mr. Borgesen testified that he had hoped to retire at age 67, that had been his wish and his plan, that his job was stressful and he wanted to reduce his hours and retire at that time. And so the court took that into consideration and fashioned a spousal support and property in lieu of alimony that would allow Mr. Borgesen to retire, no longer have to pay spousal support at the age that he requested to do so. So that goes right into, the duration was in fact a very short duration because the court didn't take into consideration what Mr. Borgesen's career looked like. However, the court did find that both parties were at the end of their careers. They weren't going to be significantly increasing their income, and that an award of property in lieu of spousal support was necessary to keep Ms. Borgesen at the standard of living that was established during marriage. And as Attorney Keywell notes, the court is very close to approximating that standard of living. Ms. Borgesen will be staying in the same house with the same mortgage debt, driving roughly the same vehicle, and living with the same day-to-day standard of living that she established during the marriage. She will, of course, have less retirement assets available to her. She'll have less income available to her. I believe that the health insurance situation had to change. And Mr. Borgesen, he was living at a standard above the standard of living established during the marriage at the time of the divorce. Now, the parties in this case have been separated for 4 years. So Mr. Borgesen makes quite a bit of the fact that he claims he was living in a sparsely furnished apartment. However, he'd been living in this, what was a newly renovated 2-bedroom apartment. He'd had 4 years where he was paying the reduced voluntary spousal support, as he calls it. And he was living at the standard that he chose. As the court noted, he was spending $450 a month eating out. He had taken up a $350 tobacco habit that he did not have during the marriage. Spending $400 on entertainment, $500 on vacation, which he testified was $200 a month increase on the amount he had been putting away for vacation. prior to the parties' separation. Mr. Borgesen also went out and purchased a brand new Denali truck. He drives on paved roads to his job centers. It's not required for his employment. And it was clear that he was living above the standards established during the marriage, and that was discretionary spending. The court explicitly noted that Ms. Borgesen was unable to meet her needs based on what Mr. Borgesen was paying at the time. Mr.
You have
Borgesen,
1 minute, counsel. You've got 1 minute.
thank you, Your Honor. I would just briefly address the curious argument about the party's adult daughter. There was no that Ms. Borgesen was supporting her beyond the adult daughter living in the house, and there was no evidence of her income presented by either party from which the court could have even considered her income in fashioning the order. And I'm not aware of any case law where that is required or has been done. So in conclusion, Your Honor, Ms. Borgesen, the trial court's decision was well within its wide discretion in fashioning a support order in this case. The court disagrees, that is his prerogative, but it is not a justifiable grounds for review. We request that this court affirm and appreciate your time. Thank you very much.
Thank you. Thank you very much. Your time has expired. Thank you both. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 9:45 this morning.